Hello and welcome to IndiTalk. This is a show on which we discuss controversial issues of national importance. And today's subject is the ongoing hearing in the Supreme Court. In fact, in the court of the Chief Justice, Justice Deepak Mishra himself, regarding questions arising from the untimely death of Judge Loya in December 2014. As you may all recall, it's been in the papers. The unfortunate death took place in December 2014 under circumstances which have been now raised into questions because of various magazine reports and because various political parties have raised the issue about the circumstances under which Judge Loya was supposed to have died of a heart attack. Now, I am not going to get into the forensics of this matter because I am no expert. But two things did catch my attention during the previous hearing on this subject that took place before the Chief Justice's court. See, one of the things that was brought up was that the Maharashtra government, when presenting its case and saying that there was nothing suspicious about the death of Judge Loya, presented in its defense certain written statements and informal documents presented by the intelligence department of the Maharashtra government. Now, these were challenged as not being admissible as a proper defense in a court of law. These were challenged by the lawyers who are asking the court to set up a special inquiry into the death of Judge Loya because they are not satisfied with the information that has been provided by the Maharashtra government so far. And one of their strongest arguments is that you cannot accept anything else except affidavits that are sworn under the legal process, which are sworn under oath, and which are prepared properly by the proper authorities. That's number one. The judges have listened carefully to this argument, but have not yet made any decision on it. The second most important thing is what Judge Deepak Mishra himself said in court, in which he said that if Section 174 of the CRPC, the Criminal Code of Procedure, has been violated, then there would be grounds for suspicion. Now, this was an extremely serious question raised by the Honorable Chief Justice, none other than the Honorable Chief Justice. Now, 174 of the CRPC lays down certain aspects, certain procedural aspects that the law enforcement authorities and others must follow, and the judicial authorities must follow before they conclude that any death is a natural death or a death that is worthy of more investigation or on unnatural causes. And 174 lays this down very carefully so that if there is a death in which even there is the slightest suspicion that it may not be because of natural causes, the state has a duty to follow certain procedures. Now, I will read some portions of 174 to you because this is, after all, a judicial matter, and I don't want to get anything wrong in this essay. See, among the things in Section 174 Code of Criminal Procedure of 1973 says that if someone has died under circumstances raising reasonable suspicion that some other person's committed an offense, he should immediately give intimation to the nearest executive magistrate empowered to hold inquests unless otherwise directed by any rule prescribed by the state government or by any general or special order of the district subdivisional magistrate shall proceed to the place where the body of the deceased person is. Also, now this is very important, listen carefully, that there should be the presence of 2 or more respectable inhabitants of the neighborhood who shall make an investigation and draw up a report of the apparent cause of death describing such wounds, fractures, bruises and other marks or injury as may be found on the body and stating in what manner or by what weapon or instrument if any such marks appear to have been inflicted. And that with a view to its being examined, a nearest civil surgeon or other qualified medical man or medical person appointed on his behalf by the state government should undertake the investigation, and the following magistrates are empowered to hold inquests, namely any district magistrate or subdivisional magistrate, etc., etc. Now, the point is that there is a process to be followed. It is not that an intelligence agency of the state writes an informal report based on information or even a written response by 4 judicial officers and then presents them as the state's case of saying that, look, this case should now be closed. And if the judge, the Chief Justice himself, has found it fit to raise a question that there may be grounds to look at the fact whether Section 174 has been followed or not, means that the Supreme Court is taking the death of Judge Loya extremely seriously, and the matter is just not going to end here without further investigation. That's all for today on IndiTalk. This is Inderjit Badhwar. We'll be back again with more burning issues. Catch us.